Every school child knows that you have the right to remain silent. As a matter of fact, in TV shows that everybody watches, you always hear the police officers going over the Miranda warnings, reading them off a card. You have the right to remain silent. If you don't, anything you do can and will be used against you in a court of law. You have the right to an attorney, and if you can't afford one, one will be appointed to represent you. And most people just refer to the Fifth Amendment as taking the Fifth. The Fifth Amendment provides that you cannot be compelled to be a witness against yourself. And in 1966, the United States Supreme Court issued a landmark opinion, which almost everyone is aware of, Miranda versus Arizona, where for the first time the U.S. Supreme Court set forth that you had to be given these rights, and that if you were not, any statement that you made could not be used against you. But there's some common misconceptions about Miranda. First of all, it only applies to custodial interrogation. And custodial interrogation is normally just what it sounds. That is, you're in custody. But it's not limited to being in custody. As a matter of fact, it's broader than that. If you are in custody or otherwise significantly deprived of your liberty, for example, if you are handcuffed by a patrol car, you are in custody. You don't even have to be handcuffed. If you are not free to leave, then you are in custody or otherwise significantly deprived of your liberty for purposes of the Miranda warning. And if you're not given these warnings, anything that you say cannot be used against you in a court of law. Now, another misconception is that people oftentimes think that if they're not given their Miranda warnings, that the case has to be dismissed against them. Nothing could be further from the truth. All Miranda does is provide a rule that certain evidence in a trial may be excluded if the police don't follow the proper procedure in advising you of your rights. Now, up until recently, everybody thought that you just had the right to not speak and it couldn't be used against you. However, recently, in 2013, the United States Supreme Court decided another case, Salinas versus Texas, that significantly reduced the reach of the Miranda opinion. And it's necessary to go into the facts of that case briefly so that you understand how Miranda was limited. In that case, two brothers were murdered by a shotgun. And the police were trying to interview various suspects and determine who may be responsible to the murder. And they were led to Salinas, who happened to be at a party at those brothers' homes the night before they were murdered. And they came by his house and they spoke with him. He agreed to talk with them. He provided them, upon their request, with his shotgun. And he agreed to voluntarily go to the police station to continue the interview process. Now, he was not under custodial interrogation. He was not under arrest. He was free to leave. Therefore, the Miranda warnings did not have to be given to him, and they weren't given to him. However, when the police were interrogating him, at first he answered all the questions they had. And then one of the police officers said, "When we examine your shotgun and compare them to the shotgun shells that were found at the scene of the murder, are they going to match?" And Salinas didn't answer that question. Instead, he looked down at the floor, he bit his lip, he clenched, and simply didn't say anything. Then they continued to ask him questions which he responded to. At trial, Salinas didn't take the stand. And at trial, the prosecution introduced the response that he had to the question of whether or not the shotgun shells were going to match his shotgun. That is, that he fidgeted, that he clenched his lip, that he looked down at the floor. They were using that to infer that that was guilt, that the reaction that he had. Of course, Salinas' attorney objected to that at the trial court level, saying that that was invading his Fifth Amendment privilege against self-incrimination. That is, that he had the right to remain silent, and that if he did remain silent, nothing could be used against him. And at least in my opinion, the Supreme Court, in a shocking ruling, said no, that in order to invoke your Fifth Amendment privilege against self-incrimination, you have to assert it. That is, that the police can use your silence against you now under certain circumstances. So the moral of that story is that if you are ever questioned by the police, you should always say, I plead the fifth, I'm invoking the fifth, I want to talk to my attorney. You should simply not respond to questions, and therefore you would be protected, and nothing you say or even your actions could be used against you from that point forward.